FBI Director Kash Patel may be out of a job in the coming months. 3 people with knowledge of the situation say President Trump and his top aides have grown tired of Patel and the unflattering headlines he's been generating recently, including using a government jet to visit his girlfriend and enlisting a SWAT team.
Kash Patel is absolutely terrified right now because federal judge just issued order that could land him in jail. Not theoretical future threat, immediate present danger. Judge told Patel produce documents in full by hard deadline or face immediate arrest by federal marshals. Said there were no alternatives left, that patience had run out, that Patel's continued defiance could result in him being taken into custody for contempt, an added devastating twist. Judge also threatened perjury charges, saying if Patel lied to court about document production, about whether he'd complied with orders, that's criminal offense carrying prison time. So Patel could be facing 2 separate charges: contempt for refusing to produce documents and perjury for potentially lying about whether he'd already produced them. This is sitting FBI director being threatened with immediate arrest by federal judge, while he's supposed to be running nation's premier law enforcement agency. And it reveals how desperate his situation has become, how much legal pressure he's under from multiple directions, because this isn't only threat he faces. Fired FBI agents are suing him with lawsuits quoting his own alleged admissions that he knew firing them was illegal. He got limited immunity deal in Mar-a-Lago case, but that protection has holes. And now reports emerging that Trump administration is tired of him, considering replacing him, all while he's staring down arrest deadline. If you want to stay ahead of the headlines, please subscribe. That's why we built Patrick Smith Show, to bring you real stories and real context. Alright, so let's start with this court confrontation because it shows how badly Patel's legal situation has deteriorated. Federal courts have broad contempt power to enforce their orders. When judges issue subpoenas or discovery orders or commands to produce documents, they expect compliance. And when parties refuse to comply or claim they've complied when they haven't, judges can hold them in contempt. Share this video with everyone you know but there are escalating levels of response. Usually judges start with warnings, then maybe monetary sanctions, fines that increase until party complies, then more severe consequences. By time, judge says there are no alternatives left. That means entire escalation ladder has been climbed. Every lesser measure has failed. Only option remaining is threat of custody. That's where this judge was with Patel, had apparently gone through multiple stages of trying to get compliance. Warnings didn't work. Patel kept claiming he'd produced everything or that he couldn't produce certain documents for various reasons. Judge kept rejecting those excuses, kept demanding full compliance, and finally reached point where he said enough. No more excuses, no more delays. Produce everything by deadline or marshals could arrest you. Think about what that means. Think about specificity of that order. Not produce documents eventually. Not work toward compliance. Produce documents in full by specific deadline. And consequence of missing deadline wasn't more fines, wasn't more warnings. Could be federal marshals physically taking FBI director into custody. That's how serious judge was about enforcement. Make sure you're subscribed to Patrick Smith Show because and judge added perjury threat on top of contempt. That's significant because it addresses different conduct. Contempt is about current defiance, refusing to comply with orders. Perjury is about past dishonesty, lying to court in previous proceedings. Judge was saying if Patel represented to this court that he'd fully complied with document production when he hadn't, that could be false statement under oath. Perjury is federal crime, carries imprisonment, not civil penalty like contempt fines, criminal charges that could send Patel to prison if convicted and if he's found guilty. So judge wasn't just threatening to jail him until he complied, was threatening to prosecute him criminally for lying during proceedings. That's additional layer of exposure beyond contempt. And this tells you what judge thought about Patel's previous representations to court. Judge clearly believed Patel had claimed he'd produced everything when he hadn't, that he'd made false statements about his compliance. Otherwise, why threaten perjury charges? Judge was signaling he viewed Patel's conduct as involving not just defiance, but dishonesty about the defiance. So Patel could be staring at 2 separate charges: contempt if he didn't produce documents by deadline, and perjury for false statements he'd allegedly already made about previous production. Even if he complied with deadline, even if he produced every document judge demanded, he could still potentially face perjury prosecution for lies he'd allegedly told earlier. Share this with everyone because that's compound legal jeopardy. Can't escape exposure just by complying now. Past conduct has created vulnerability that exists regardless of future compliance. Judge had backed Patel into corner where he could face arrest either way, either for continued defiance or for past dishonesty. That's how badly this situation had deteriorated. Now let me talk about what these documents likely involve. Because Patel isn't facing arrest threat over parking tickets. This is almost certainly related to cases involving Trump. Either Epstein files that courts have ordered FBI to produce, or documents related to FBI investigations, or materials connected to agents Patel fired. Whatever specific case is, documents are clearly significant enough that judge considers Patel's refusal to produce them serious defiance. And Patel's pattern has been to claim various reasons why he can't produce documents: classification concerns, ongoing investigations, privilege claims, executive authority. Every excuse in book for why FBI doesn't have to comply with court orders. But judges have rejected these excuses, have said classification doesn't exempt FBI from judicial orders, that ongoing investigations don't justify indefinite withholding, that privilege has limits. So Patel kept losing those arguments, kept having his excuses rejected, yet kept refusing full compliance. That's what exhausted judges' patience. Not that Patel raised legitimate concerns, but that he kept raising concerns that had already been litigated and lost, kept trying to relitigate decisions that were already made, kept acting like FBI was above judicial authority. That's why Judge finally said no alternatives left, because Patel had demonstrated through pattern of behavior that he wouldn't voluntarily comply, that warnings wouldn't work, that sanctions wouldn't work, that only threat of immediate custody might force him to actually produce what court had ordered. Judge had tried everything else. Arrest threat was last resort. And think about what this means for Patel personally. He's sitting FBI director, one of most powerful law enforcement officials in country, and he's being threatened with potential arrest by federal judge, being told that federal marshals could take him into custody if he doesn't comply. That's humiliating. That's devastating to his authority. That's FBI director being treated like common criminal who defies court orders. Think about what that means. But it's also revealing about how Patel has operated, because pattern suggests he views himself and FBI as not subject to judicial authority, as able to refuse court orders based on executive branch claims, as operating above the law. And judges are rejecting that, are saying, no, FBI director is subject to court orders like everyone else. Produce the documents or potentially go to jail. Now let me connect this to other legal pressures Patel faces, because contempt threat isn't only problem. Fired FBI agents are suing him in multiple federal lawsuits, and these suits include devastating evidence. They quote Patel allegedly acknowledging that firing agents without cause would violate FBI rules and federal law. Quote him acknowledging he knew he could be sued. Quote him saying his job depended on removing agents who worked on Trump-related cases. If those quoted statements are accurate, if Patel actually said those things, then he admitted he was breaking law, admitted he knew conduct was illegal, but did it anyway because he believed Trump expected it. That would be knowing violation of law. That would be deliberate law breaking to serve presidential interests. And it's documented in federal court complaints. Those admissions could be devastating in civil lawsuits, because normally plaintiffs have to prove defendant knew conduct was unlawful, have to establish through circumstantial evidence that person understood they were violating law. That's difficult burden. But if Patel admitted it himself, if his own words establish knowledge, then plaintiffs don't have to prove anything, just have to authenticate the statements. And authentication is straightforward if statements came in congressional testimony or documented conversations. If there are transcripts or recordings or witness testimony confirming Patel said these things, they could be admissible evidence, could be used against him in trial, could make liability almost certain because he'd convicted himself through his own admissions. So Patel facing massive civil exposure from those lawsuits, potential damages that could bankrupt him personally. potential findings that he violated constitutional rights of agents he fired, all because he allegedly admitted he knew conduct was illegal but did it anyway to keep Trump happy. That second major track of legal pressure operating simultaneously with contempt threat. Third track is criminal exposure from Mar-a-Lago investigation. Patel was involved in classified documents case. Prosecutors wanted his testimony. He repeatedly invoked Fifth Amendment, right against self-incrimination, refused to answer questions about what he knew and what he did regarding those documents. Fifth Amendment invocation itself is revealing. You invoke Fifth when you believe truthful testimony could incriminate you, when answering honestly would provide evidence that could be used to prosecute you. Patel invoking Fifth repeatedly means he believed testimony about Mar-a-Lago documents carried criminal risk. That answering truthfully could lead to charges against him. Justice Department eventually got court order compelling testimony after granting limited immunity. That immunity meant his testimony couldn't be used directly against him in prosecution. Standard practice when prosecutors need testimony from witness who won't provide it voluntarily. Give immunity to get testimony. But immunity has important limitations. Doesn't protect against perjury during immunized testimony. If Patel lied while testifying under immunity, those lies aren't protected. He could potentially be prosecuted for making false statements. Immunity covered truthful testimony, not lies, and doesn't protect against prosecution based on evidence discovered independently. If investigators learned about Patel's conduct through sources other than his testimony, they could prosecute despite immunity. So even with immunity deal, Patel has ongoing criminal exposure. If he lied during testimony, that could be perjury. If evidence emerged through other channels showing his involvement in improper document handling, he could potentially be charged. Immunity blocked one evidentiary path but left others open. That's third track of legal pressure he faces. Now let me talk about why all this pressure is building simultaneously. Because it's not coincidence that Patel faces contempt threat, civil lawsuits, and criminal exposure all at same time. Pattern suggests he's operated throughout as someone who viewed himself as above law, as able to defy courts, violate constitutional rights, and obstruct investigations without consequences. Think about what that means. Contempt proceedings show him defying judicial orders to produce documents, refusing to comply despite repeated commands, acting like FBI doesn't have to answer to judges. Civil lawsuits show him firing agents he allegedly knew he couldn't legally fire, potentially violating their rights despite knowing it was illegal. Criminal exposure shows him invoking Fifth to avoid incriminating testimony, then getting compelled under immunity. Each situation involves Patel allegedly putting Trump's interests above legal requirements, protecting documents that might be damaging, purging agents who investigated Trump, refusing to testify about classified documents, all serving Trump while potentially violating various legal obligations, and now facing consequences from multiple directions as courts and plaintiffs demand accountability. And there are signs Trump administration is growing tired of him. Reports that Trump and top aides frustrated with unflattering headlines Patel generates, using government jet to visit girlfriend, enlisting SWAT team as her security detail, making premature tweets about investigations, getting out ahead of announcements before rest of government ready. That's significant because Trump's protection is only thing keeping Patel from complete legal disaster. If Trump turns on him, if administration fires him or forces him out, Patel loses institutional protection, becomes former official without power or resources of FBI behind him, much more vulnerable to prosecution and lawsuits and judgment enforcement. So Patel has to be terrified, facing immediate arrest threat from judge if he misses deadline, facing devastating civil lawsuits with his own admissions as potential evidence, facing potential criminal charges despite immunity deal, and facing possible loss of Trump's protection as administration grows frustrated with him. Every pillar of his position is crumbling simultaneously. Now let me address what hard deadline means practically. Because when judge says produce documents by specific deadline or face arrest, that creates impossible pressure. Patel has to gather every responsive document, has to ensure nothing is withheld, has to deliver everything to court by deadline, all within limited time frame. If he misses deadline, if he produces most documents but not all, if he claims some can't be produced for any reason, marshals could arrest him. No second chances, no extensions. Judge made clear that no alternatives remained, that this was final ultimatum: comply fully or potentially go to jail. That forces Patel into terrible choice: produce everything including documents that might incriminate himself or Trump or reveal FBI operations, or refuse and potentially go to jail for contempt while also facing perjury charges. Either option has severe consequences. Either he betrays Trump by producing damaging documents, or he could go to jail for protecting Trump. And that's squeeze play judges use on people who've defied orders too long. Make deadline tight while keeping requirements strict. Full production required. By hard deadline. No exceptions. If person can't possibly comply, that proves they were never going to comply. Justifies arrest. If person somehow does comply, court gets what it ordered. Either way, judge wins. Patel probably tried to negotiate, probably asked for extension. More time to gather documents, more time to review for classification, more time for anything, but judge said no alternatives left. Deadline stands. Produce everything or potentially go to jail. That's judge who's done negotiating. And Patel's only real option at that point would be compliance. Produce every document judge ordered. Hope that's enough to avoid contempt, though perjury threat remains for past false statements, or face potential immediate arrest and all consequences that flow from FBI director being taken into custody by marshals. Think about how that could look. Federal marshals arriving at FBI headquarters, potentially arresting the director, taking him into custody in front of his staff, booking him like common criminal. That would be humiliation beyond measure. Would effectively end his tenure as director, would destroy whatever credibility he had left, would make him liability Trump couldn't keep protecting. So Patel had enormous incentive to comply, to produce documents and avoid arrest, but compliance means potentially providing evidence against Trump or himself, means revealing whatever FBI has been hiding, means choosing between arrest now or potential prosecution later for what documents reveal. No good options, just choosing which disaster to accept. Now let me talk about broader implications of FBI director facing arrest threat, because this isn't normal. FBI director is one of most powerful positions in government. Head of nation's premier law enforcement agency, person who's supposed to enforce laws and ensure compliance with judicial orders. And here we have FBI director himself being threatened with arrest for defying court. That shows how far Patel has pushed boundaries, how much he's defied normal legal processes, how thoroughly he's prioritized protecting Trump over complying with legal obligations. And it shows judges are willing to hold even powerful officials accountable, willing to threaten arrest, willing to use contempt power against FBI director. That's significant because it suggests judiciary isn't intimidated by executive power, isn't willing to give FBI pass just because of institutional importance. If FBI director defies court orders, he could face same consequences as anyone else. Arrest, prosecution, conviction. That's rule of law operating even against powerful officials. But it also shows strain on system, because normally FBI director would comply with judicial orders, wouldn't defy courts repeatedly, wouldn't force judges to threaten arrest. Patel's conduct represents breakdown of normal cooperative relationship between judiciary and executive. Shows what happens when executive branch official views himself as above judicial authority. And that's pattern we're seeing across Trump administration. Officials who view themselves as not subject to normal legal constraints, who defy court orders, who refuse oversight, who act like executive branch operates above law. And slowly, gradually, judges are pushing back, threatening contempt, issuing arrest threats, trying to enforce judicial authority. Question is whether it's enough, whether threat of arrest will force compliance, or whether Patel and others will continue defying courts even at risk of custody. We're testing boundaries of judicial power against executive defiance. An outcome will determine whether rule of law still functions when president's loyalists refuse to comply. Bottom line is this: Kash Patel is scared of arrest because federal judge issued instant order demanding full document production by hard deadline, or he could face immediate arrest by federal marshals. Judge said there were no alternatives left. That patience had been exhausted. that Patel's continued defiance could result in custody for contempt. Judge also threatened perjury charges if Patel lied to court about previous document production. That's criminal offense carrying prison time. So Patel could be facing two separate charges: contempt for current defiance, perjury for past dishonesty. Even compliance with deadline wouldn't necessarily avoid potential perjury prosecution for false statements already made. This shows pattern of Patel defying judicial authority, refusing to produce documents despite repeated orders, making excuses that judges rejected, acting like FBI is above court oversight. Judge finally reached breaking point, said no more warnings, no more delays, produce everything immediately or potentially go to jail. Patel also facing civil lawsuits from fired FBI agents. Lawsuits quote his alleged admissions that he knew firing agents without cause would violate law, that he knew he could be sued, that his job depended on removing agents who worked on Trump cases. If authenticated, those admissions could prove knowing violation of law, could make civil liability almost certain. Criminal exposure remains from Mar-a-Lago investigation despite limited immunity. Immunity doesn't protect against perjury during testimony, doesn't protect against prosecution based on independently discovered evidence. Patel's Fifth Amendment invocation showed he believed truthful testimony could incriminate him. Immunity got prosecutors' testimony but left pathways to potential charges. Reports suggest Trump administration frustrated with Patel, tired of unflattering headlines, considering replacement. That threatens to remove institutional protection he needs, makes him more vulnerable to legal consequences without FBI resources and presidential backing. All this creates compound jeopardy, immediate arrest threat if deadline missed, civil lawsuits with devastating admissions as potential evidence, criminal exposure despite immunity, possible loss of Trump's protection, every track operating simultaneously, every pillar of his position crumbling. That's why Patel is scared. That's why instant court order posed existential threat. This continues. Stay tuned.